Okay, welcome back to House Human Services. This afternoon, we're going to take up a couple of things. We're going to be doing markup of S-157, reviewing the latest changes and doing further markup. And then we are going to do things a little backwards, I realize, but we're going to hear from a witness on S-193, even though we haven't had a walk through the bill yet, but we will be getting a walk through the bill. But we were able to get this witness and we had a time slot. And so we're going to do that. And that is an act relating to establishing a forensic facility for certain criminal justice involved individuals. And for us, in particular, we'll be dealing with folks with developmental and intellectual disabilities on how that bill works. We are going to have a sign that I'm going to paste right up here that says, "What would Ann do?" I told her that because trying to keep that in mind, that bill is one in particular that she's interested in. So
Absolutely. Thank you.
okay, thank you, Katie. You can go ahead with the changes that we've made since the last time, and I'm sure we're going to have some more.
Okay, sounds good. Katie McGlynn, Office of Legislative Counsel. Good afternoon. Here is the latest draft. Okay, so this is draft 1.1. We made a few changes since yesterday. We have the definition section in section 1, no changes there. No changes in section 2, which is where we have the list of programs administered by the division. Section 3, this is our section and subdivision B1 about immediately exiting or transferring a resident. There were some changes here. So first in Roman numeral 5, what is the lead in here? So this is all the contents of the conditions that must be met to immediately exit or transfer somebody. So indicating that by signing a residential agreement, a resident acknowledges that the recovery residence may cause the resident to be immediately exited or transferred to alternative housing for behaving in a manner that impacts the health or safety of other individuals residing, working, or volunteering at the recovery residence, such as the resident violating the recovery residence's substance use policy, repeatedly refusing to engage in services or programming, being charged with a criminal offense, engaging in theft, materially interfering with the recovery of other residents, or engaging in acts of violence that threaten the health or safety of other residents, recovery resident staff, or volunteers. And then in subdivision C, we have sort of the corresponding language that the resident behaved in a manner that impacted the health or safety of other individuals residing, working, or volunteering in the recovery residence, as, and then the same list, violating recovery resident substance use policy, repeatedly refusing to engage in services or programming, being charged with a criminal offense, engaging in theft, materially interfering with the recovery of other residents, engaging in acts of violence that threaten the health or safety of other residents, recovery resident staff, or volunteers. Striking out the "and" there because we're adding to our list. So the "and" drops down one subdivision. And in subdivision E, new language, that the recovery residence has established a grievance process approved by the Department of Health, a Vermont affiliate of NAR, or another organization approved by the department. So this,
Can I just ask you to stop for a second?
Yeah.
Meg, could I ask you to give us some ventilation on that window? Just, I don't know if it's hot flashes or if it's.
There are no screen or anything. It is like.
Yeah. Thank you.
Watch out for Eric.
He's out.
oh my God.
Thank you. I'm sorry. I'm just literally like burning up on this end of the table.
Yeah. Miss, open the door.
If it's quiet out there, that'll be at least part way. You can open it part way, give us some ventilation.
Are those in?
That does.
They have to come, I'm gonna ask them to come.
Oh.
They have to take the storm off, in other words. So, sorry, that's all I could think about right at this moment was being so hot up here. So, I'm sorry. Thank you.
This room is warm. As soon as we opened that door, we felt a breeze come through. So this subsection or subdivision E, just to make sure you know how this falls, this would be a requirement on the list of requirements that a recovery residence would have to fulfill to be able to immediately exit or transfer somebody. So it's another entity added to that list. You decided to keep this subdivision 2 and then add a new subdivision 3, which is notwithstanding 4460 of this chapter, a recovery residence employee may enter the recovery residence at reasonable times as necessary to carry out any function related to the operation of the recovery residence. Updated definition. So remember the choice you made was that this section on exiting and transferring individuals would apply to a certified recovery resident. So we can't just have a cross-reference anymore. So now it reads, as used in the subsection, recovery residence means a shared living residence supporting individuals recovering from a substance use disorder that provides residents with peer support, assistance, accessing support services, and community resources for individuals recovering from substance use disorders, and is certified by an organization approved by the Department of Health, and that is either a Vermont affiliate of the VTAR, of National Alliance of Recovery Residences, or other approved organization.
Is there a reason, I was just recalling when Jen was in here earlier and switching from persons to individuals. Is that because we're specifically meaning a person and not person as it's been sort of legally defined?
I use individual, so it doesn't mean an organization.
Organization.
Yeah, that's what she said.
Yeah,
You want to have
that's what I'm just-
confusion with an organization or corporation, that the retailer or
Right.
wholesaler.
Yeah, no, I get that. I was just wondering if that was
Yeah.
same rationale that you were using here. And then I'm just wondering about the use of the term resident versus individual again. Are you
That was.
trying to distinguish it?
Yep, that was taken from the definition in section 1. And where is it? Let me make sure I'm giving accurate.
Yeah, it's right on the very first page.
So
Yeah.
I used it from there, but the decision that you made a few years ago was that this was a tenancy, a landlord-tenant
yeah.
situation. So that's why the word residence is used here.
Okay. I wasn't, thinking about the difference between landlord and tenant. I was just thinking about like referring to people as people, as opposed to titles. I mean, I'm gonna think on that for a while.
You're pointing out the contrast between line 1, residents, line 3, individuals,
Sorry, let me,
top of page 6.
it has 2 different words in the same definition. Let me take a look.
Because I guess what I'm wondering what is to be gained by referring, I'm looking at, on page 1, but it's referencing the same thing as what you're talking about there. I'm trying to figure out what's to be gained by going back and forth. We refer to supporting individuals recovering from substance use disorder that provides residents as opposed to individuals with peer support. And then we come back to community supports for individuals recovering from substance use disorder.
Well, that's a good point. Community resources.
Well, community
Residents.
resources would provide for residents.
Yeah, it's a broader
It's a broader,
population survey.
But this is the definition of recovery residence.
And residence only serves the people who live there.
But they're connecting you with community resources
for
for individuals. So a community resource that's serving a population broader than just residents.
Right. All right, I'm good. Like, we can think on that a little bit. I mean, I remember the whole discussion about tenant and resident and all of that.
But now that we're striking out tenant, I see your point, is why are we sometimes referring to them as residents?
And sometimes it's individual.
Switching back and forth, now that you've pointed it out, I don't feel comfortable with it. It's a shared living residence supporting individual recovering from the provided.
Because it makes it feel like we're talking about somebody unique or different, and I'm not sure that we are. That's what I'm trying to grapple with in my brain. Are we talking about, do we have
Could we just stop after community resources?
Then you're not certifying.
Oh, that's what the certification is, that they supply that services. I see.
Yeah.
So let's just noodle on this a little bit more. I don't think we have to make a decision right now, but I'm just trying to figure out if, I know that we had a lot of discussion previously about this, and, I'm just trying to figure out if it really, it was, and what I'm trying to get at is, I guess they're, all of those people are individuals. And, are we, I know that we are only referring to those people who are living there. And, I don't know, I might have just opened up a can of worms, but.
No, I think you could say, I'm feeling like you could take out individuals and replace it with residents. And I'm not sure that we would lose any of the meaning.
My preference would be go to the opposite.
Oh, really? I'm just thinking it's a specific person who's, it's not just any person that they're
Someone who
providing
resides
service.
there.
Yeah, it's the person that is living there. So it means a shared living residence supporting residents, not just anyone recovering from a substance use disorder, provides residents with peer support, assistance, accessing support services, and community resources for residents recovering from substance use disorder.
Right, because I don't think that last one, I'm not sure I agree with you, Doug, when you're saying that that's sort of the access to, I think it's access for them. Residents with peer support, assistance, accessing support services and community resources. Oh, maybe I'm gonna flip that back on that. I think I think it is individuals in the last instance.
Are the, so this is the recovery residents providing community resources. Are they providing community resources to anyone? Or are they providing them to their residents?
Well, with assistance, accessing support services and community resources, it's assistance provide, so they could be providing them access to recovery center services, for instance.
The comma makes me feel like it's a list instead of.
Yes, that's what Doug is saying.
Okay.
So I think it is individuals in the last instance.
And I don't think that in the first instance, it should be changed to individuals. I think it needs to stay as residents.
I'm okay with, but I think they both need to be the same. I don't think it should stay individual and then switch to resident. Because they only are serving the people who live there.
Yes. But I feel like the last one should be residents. They provide residents with peer support. That's the first thing on the list. They
Mhm.
provide residents with assistance accessing support services. That's the other item on the list. And they're providing tenants with community resources. That's the third thing on the list. They're, what did I say? Okay, thank you. Residents with community resources. So it's not, they're providing assistance accessing the community resources. It's another item on the list.
It's other community resources for people with substance use disorders. So it could be access to hub and spoke treatment. It could be access to recovery centers. It could be access to, I don't know, Valley Vista, we heard from this morning, other treatment.
I think if that's what you want to do, then we take out the list format and say, provide residents with peer support and assistance accessing support services and community resources without the comma.
Well, I look at the crossed out language, available to persons. That's what it's trying to get at. And so somehow for individuals got substituted for individuals.
Mhm.
And what it's trying to say is that it is a list of things that are going to be outside of the home.
What happened if we just revert back to the available to persons?
Well, you can say available to individuals. It's, if we're having disagreement about what it means, then people reading it are gonna have disagreement about what it means.
Available to individuals recovering from substance disorder.
So is the peer support provided by the recovery residents? Because this makes it sound like yes.
The peer support is.
And then the assistance accessing support services and community resources is just that. It's just an access to outside resources.
So I'm gonna call on, phone a friend.
Mhm.
Go ahead, Emily.
And the Trigger Health Department, it can be both. So I think it depends on the NAR level, it depends on the geographic location of the house and what's available to them in those spaces. They may have stuff that happens on site, but they also may be referring to their communities. So it needs to have a space for both relationships.
That says explain.
Well, we could just say, and community resources related to recovering from substance use disorders and get rid of it altogether.
Okay.
How's
Good
that?
executive decision, Madam Chair.
Thank you, Emily.
Read that.
So it will now say provides residents with peer support, assistance accessing support services, and community resources related to recovering from substance use. And we could say, and other community resources related to recovering from substance use disorders.
And are you keeping the comma after services? You're making a list
Yes.
so that it stands.
Yes, it's a list,
Yeah.
yes.
Okay.
And then
It
And
also
we'll
needs to be changed.
change on page 1 as well.
Yep.
Okay. And on page 1, we're going to switch that into the first individual to residents. Okay.
Section 4 is the strikeout of the repeal. Section 5 is the rulemaking on recovery resident certification. And language added here, that part of the rulemaking is going to set forth data collection standards and reporting requirements for certified recovery residences, including data elements and frequency, exit and transfer data, and requirements for annual reporting.
Yes, that's where we added the information that you were looking for, Representative McGill, on the exit and transfer data.
Yeah.
Okay. All right, so we've had some testimony in the meantime. We've had some feedback, also some written testimony that I would like to take a look at. And this was, I asked a question earlier that people might not have, oh, no, this is when we were just talking, I think. So one of the pieces of feedback was, and Meg, you may know the answer to this. If you don't, I'm sure you're going to be able to find it for us. Does a recovery residence provide anything in writing to the individual when they're being asked to exit? So do they say, you're being exited on such and such a date for this reason? Here's, and this is where you're going according, to their safety plan or whatever. And here's the procedure to request, a return to the residence or something like that.
I think also note hit was the reason why they were being.
Yes, yeah.
Yeah.
Do you know if that exists?
There's written notice, but I just asked.
Okay. Okay, thank you. I think actually that would be something that we would like to
I
insert
was
here,
just gonna
Katie.
ask if that's okay.
I'm just seeing, oh, it's on our website. This is from VCJR, one of the pieces of feedback that they had, and another witness had that earlier today. About a written notice when somebody is being exited or discharged or however the term is that they're using, the reasons why, what the date is, and what the procedure would be for asking for reconsideration or a return or of that notice. So I think we would like to see that specifically listed in the bill.
Okay.
So there was, one of the things that I'm wondering about is, there's a question about whether we want to, a suggestion to strengthen the definition of safe alternative placement. No suggestions about exactly what that might look like, but, and do we actually, we don't define alternative placement. What I'm trying to balance is, we definitely have evolved, you know, in terms of the system of supports available to people, who are both in recovery residences and being asked to leave for either a temporary or permanent time. And we heard today about some of the access that they have to re-engagement, services and, re-engaging in treatment if they are open to that and need that. We did add language about that they have to have an established grievance process approved by the DOH and the VTAR, which is not something that was there previously. So I think between the grievance, you have somebody who's going to come in.
If you would like David to join us.
Okay, that would be fine if he's able to answer a couple of our questions. That would be great. David Regal.
Does he need the Zoom link?
Yes, oh, yeah, you would need this.
While we're waiting for David to join, on page 5, on line 17. This is a little thing, but, to me, it makes a big difference. Carry out, I would like to delete any functions, any function, and just write carry out functions related to the operation of the recovery. I don't want it to be just a blanket carte blanche about anything.
While we're on that, I'm not sure I have clarity on where we land with this language, notwithstanding section 4460, a recovery residence employee may enter.
Yeah.
What do they have? Is that access to every room, every corner of the building, or is it just the common areas? I'm not sure how that's impacted by the notwithstanding.
I think this wording, I mean, yes, I think this wording is pretty broad, that it would allow access.
And most of the time it's to common areas, but I can also see a time when they would need to enter a residence room.
I can too. I just wasn't clear on what we.
This provides access to any place in the home. Okay, thank you. Can you change the view? Thank you. Thank you, David. We were just asking, one of the pieces of feedback that we got this morning was suggesting that people receive a written notice that they're being asked to leave that states why and, you know, sort of what's the reason. And then I added this part, you know, whatever opportunities there may be to be considered for reentry into the home, you know, how they might reapply to be to come back. Are there written? I don't know the certification requirements well enough to know whether that's a requirement of national certification or not.
I'd have to let Jeff speak to whether it's a requirement for certification. We do provide email notifications to folks that has to do with when we're operating with corrective actions, but also exits as well. I think temporary removals get a little bit tricky because they can be chaotic in the moment, depending on what the reasoning is for a temporary removal. If somebody's actually intoxicated or under the influence, our priority is keeping them and the other members of the home safe in the moment. So the follow-up email, then often comes after they've stabilized a little bit and what would it look like for them to return to the home at that point. Anytime there's an actual exit, that is communicated in writing. And most of the time we try to actually do it with a phone call or in person first, and then the email comes as documentation after.
So I think that, so we're going to add a section that requires a written notification. But I think that will leave timeframes open and let that be done in rulemaking, to allow for that there might need to be something, as you just stated, that happens immediately. And so there probably would be a period of time allowed for that written notification. And I'll leave that up to the rulemaking process where people can provide feedback and input about that, rather than sort of setting it in statute, I think. Are people okay with that approach? Okay. All right, that's helpful. So I guess it doesn't matter if it's required in certification, we're going to require it in Vermont. Okay. And then we were just talking about the request and feedback that we received in written testimony for asking for to not withstand Chapter 4460, which is access into the home. I don't know if you have open version 1.1 dated yesterday at 2:32. On page 5, you can see paragraph 3. And the way it's being contemplated right now, that is pretty broad access, to any place in the home. And I guess what we are wondering is whether there should be some limitations placed on that. I know we heard testimony from somebody, I can't remember exactly who it was, but said that from time to time, it's generally in the common areas of the home, but from time to time, they have needed to enter people's resident bedrooms if there's some sort of difficulty happening between residents, or somebody's personal property needs to be retrieved and, given to them, or, things like that. Can you maybe elaborate a little bit how this exclusion would apply, for the residents that you operate?
Absolutely. It's a really difficult needle to thread in this particular instance, because while we do everything in our power to try to make sure that staff are staying in the common areas and really respectful of individuals' personal space, there are certainly times where if somebody's reporting that they think there's an actual substance in somebody's room, or there is some sort of difficult situation by two people that are in a double occupancy room, or there's a member who's left and they've left their personal belongings in the home, and our staff are trying to help pack those up and have them ready for them or their family or emergency contact to come pick up. There are definitely situations where, we do need folks to be able to have access to all areas of the house.
Questions from people about this? I think that it's pretty broad, but I also totally understand what you just said. I mean, I think there are instances, and I'm not exactly sure. And again, maybe this could be, I'm glad the department's here. So maybe this could be another item that if there's more specificity spelled out in regulations and rules about, under what circumstances kind of thing. I don't want to get too specific in statute, but I also recognize that we are, providing an exclusion to a pretty broad piece of statute. So I don't want us to lose sight of that fact as well.
I think we'd be happy to work with the department and with VTAR through the rulemaking process to try to find something that strikes a balance.
Okay, I think, does that feel comfortable to people? For now, at least, okay. Okay, thank you. All right, other thoughts that people have? We're in markup mode, so I don't need to be the only one talking.
Just going through, I know it was both in some written testimony and testimony we heard today is just doing a check around using stigmatizing language. So it's just, I think, it's really just on that first page. I think a lot of other statutes where it's gotten updated more recently seem to be using the marks, terminology we usually do, but I think probably the substance abuse crisis team,
Mhm.
substance abusers are probably the terms that
Yeah.
raise some flags.
Yep, that's really good.
So I would suggest we use person with substance use disorder.
Mhm.
And then like substance use crisis team or I'm not sure, but
I'm gonna just check in to ask
Yeah.
Emily, like, what is that?
In general, for us, even at the federal level, it's either moved to substance misuse for the prevention of
That was my
substance
other-
use, and then substance use disorder, because
Yeah.
it's a chronic health condition speaking to that one. And anything that starts with the AD essentially has been removed from the dialogue.
So I guess my question is, so thank you for that. But what is this emergency crisis team, this substance use or misuse crisis team? It's approved by the secretary. And that means human services, I'm presuming it's not a federal thing?
I'm pulling up the chapter now.
Okay.
So because you've changed those, we'll have to change in statute where they appear. So I'm gonna check and see how many
Oh,
and where they appear.
so we're gonna make the bill longer is what you're saying.
Yes. Well, we don't know how many times it appears. It might. That's still.
Since it's defined, my guess is it appears a few times at least, since it's got a definition.
Okay, it didn't, substance use crisis team did not show up on a word search of that chapter.
Now, what about substance abuse crisis team? It's abuse.
Oh, abuse. Yeah, you're right.
While she's doing that, do you know what this is referring to?
I don't, it's not something I actively engage with, we have everything from crisis teams in our system, we have mobile crisis, that's part of that, that's not a term that we actively use in our space or that I engage with.
What purpose do they serve, I'm wondering?
It does, it's not appearing, but substance abuser shows up three other times.
Well, it's
one of the places it shows up is in the
Yeah.
definition.
So Katie, rather than you sort of on the spot doing that, if we, it might be an outdated reference. I mean, we might be able to get rid of it altogether.
It's like they're all used in this definition section. So
Would there be a definition for something that's not used in the?
well, for example, here, let me pull it up. So it's in the definition of treatment. It was in.
Oh, yeah, I mean, substance abusers, I get that. Sorry, I was.
Oh, the team.
This team, yeah.
The team, I don't know, it doesn't appear in the chapter. I'll show you, substance abuse. Crisis. Oops, there it is, now it's showing up, I'm sorry. Team,
Law enforcement.
so 3 of 6 times that it appears.
Designated substance abuse counselor.
I guess it sounds like these are local teams of some sort. But they're designated by the Secretary of Human Services. Yeah, go ahead,
And for
Emily.
Health department, and there are different things we do if something happens. If there's an overdose spike, for example, and they bring together to the AHS field services directors, which they certainly come together in that space. I don't know if there's a proper name any longer. We would take that back and take a look. It's not something that I'm currently familiar with.
Okay, that would be great if you could take that back and see if we need that reference there, or if we should substitute it with something else, because we don't like the wording of it anyway, so.
And I see a whole bunch of like substance abuse used over and over.
Do you know what this is? This is what previously we called public inebriates, this section,
Okay,
3810.
all right,
So this has been kicking around for
a while.
15 years.
Yeah.
Didn't we just change it last year?
You did.
So we just
You
changed
did.
it, yeah.
Well, you finally stopped the problem of where every year you have to move the sunset out. So does that mean
Did
that
we
this
didn't
is?
change some nomenclature as well in S 36?
I
This
think-
is probably under the ...
Yeah,
Yeah, so we didn't see.
So we didn't see the whole,
and that's why I think these things are still in there, because they've been up until now in the ...
Pieces for you to let me get rid of that.
okay, so our preference, we're going to hear back from the department about whether these things are called something different now. If they're called something different, then we'll substitute them out for this, but we do want to get rid of the we want to update the language.
Okay. Okay,
And the same thing for substance abuser.
got it.
I was concentrating on the rest and I was like, I don't know where she's talking about because I don't see it in any of
I
those.
started
And then-
like midway through
Yeah.
and I was like, huh, and then
Where
I
is it?
went back and yeah, I think it is it's just in prior times when we've edited and updated, these particular ones have been in the ... So we haven't reviewed them.
So we have an opportunity here, so we'll take it.
And you said person with substance, change it.
Yeah, person with substance.
That's actually the correct
Whatever.
terminology
Yeah.
as outlined by SAMHSA, National Health
Yeah.
Institute, and the American, so yeah.
Yeah.
Katie's shaking her head no.
Oh,
Individual substance use disorder.
okay, yes, there we go. I
Okay,
should have gotten that, given all of our conversations
Right?
today.
Okay. Okay, do people have any other sort of like overarching things like that? Any other specific things? Okay, I think we'll get one more round out of Katie. I think, before I say this out loud, let me look at my handy dandy agenda. And potential vote, we're all set, okay? That would be great if we have an opportunity, and that's tomorrow morning, oh, Katie.
oh, I'll need a response from the health department.
Yeah. That's a 9 AM tomorrow morning.
We have some notes about all of these things that are outdated in these chapters, but I think it would be like biting off a lot to do that, so.
We're just talking about this one,
Just those.
Those two terms.
just those two terms in this one thing. And I don't want to refer to something in statute now that if that's not what it is anymore, like this team thing. And if the secretary is not designating anybody to be this team anymore, then we got the chapter open, we might as well make it current. If that's possible.
I don't know, I would think right after this.
Okay, all right, and then if you all could just be in direct contact with Katie, that would be great. Katie, if it turns out that they need more time on the team thing.
Yep.
Then let's just change the name of it here to substance misuse.
Okay.
Team, crisis team. If you need more time to like ferret out whether it's an active thing or what, I don't want to get rid of something that is out there that is doing, but also if we can update it to be reflective of current practice without too much work, then, or too much confusion, it would be great to do that as well. Okay, thank you, Katie.
You're welcome.
We are moving on to another exciting topic, which is with our witness, Susan Aronoff, and I see the Dale folks have been here, Dale folk. Come on in, Susan. Thank you. This is with regard to the forensic facility bill, which is S 198. 193. Oh, yeah, we don't have it on our board yet. That's why I don't see it. The Senate bill line is getting longer and they're moving their way through the various committees. So we are going to have a walkthrough of the bill, but Susan is going to be able to give us a perspective of the DD Council, and she has also testified both in the Senate, and I don't know if you've been downstairs in Judiciary yet, but
Judiciary, but not in corrections.
corrections. Yeah. Okay. So welcome and thank you for being here.
Thank you. Hi, so for the record, Susan Aronoff from the Vermont Developmental Disabilities Council. And I don't know, honestly, if I've ever testified before your committee, but
Oh, yeah, you have.
I haven't testified
For a while.
this session, and I haven't said much about the Vermont Developmental Disabilities Council. So the Disabilities Council, I am a state employee. Anyone who gets email from me knows that because it says vermont.gov. But it's really important. I give this disclaimer whenever I testify publicly, particularly if I'm about to testify publicly about something the Agency of Human Services is proposing that the Developmental Disabilities Council might not agree with. And that's because while I am an Agency of Human Services employee, I do work for the Developmental Disabilities Council. Every state and territory has council. Ours in Vermont is entirely federally funded. We were created under a federal civil rights law for people with disabilities. And in order to get that federal funding, the Agency of Human Services signs a memorandum of understanding, like an MOU, that gives the employees of the Disabilities Council the right to testify publicly, to take positions that are at odds with the Agency of Human Services. So everywhere I testify, but especially in this building, I just always like to be really clear that while I work for the Agency of Human Services, I am not speaking for the Agency of Human Services. Rather, I'm speaking for the Vermont Developmental Disabilities Council. By law, we are made up of 60% of our members that are appointed by the governor have to be people with disabilities and their family members. And we exist, our federal charge is to basically, I'm not going to read everything here, but basically to advocate for people with disabilities and to bring the voice and the interests of people with disabilities to the places where decisions about them are made. And thanks to your chair, one of the things our council does is we try not just to speak for people with disabilities, but to really make sure that people with disabilities and their family members are able to come to the State House on a regular basis and to connect with you and their other representatives. And we do this because our motto is every day for a person with a disability and a family member, every day is Disability Awareness Day. And a couple of years ago, after COVID, when we were all still doing remote Disability Awareness Day events, Chair Wood kind of laid down the rule and said, no more of these remote events. You guys have to get back into the building. And really, it would help you out in your leadership role if we could have people with disabilities in the building really a lot, often, every day that isn't Disability Awareness Day. It's a good day for me if I'm not here alone, but rather have someone, one of my council members or a guest with me.
And we occasionally get homemade chocolate chip cookies.
We call it cookie diplomacy.
Yeah.
Cookies. So the basic position of the Vermont Developmental Disabilities Council, we sort of like to follow the Americans with Disabilities Act and the Olmsted decision from the Vermont Supreme Court that really, whenever possible, services should be provided in the community. And what our basic concern about the forensic facility is a couple of years ago, there was a study committee, Representative Garofano was on it, I was on it. What we really discovered is that particularly for people with developmental disabilities, the programs serving people in the community, the crisis houses, there's a lot more room there to build in safety, safety for staff, safety for the community that doesn't exist now. And I am really channeling Representative Donahue, and I really miss Representative Donahue right at this moment. But one of the things that we had discussed was just, looking for ways to beef up the community system so that an institutional setting isn't necessary. It might surprise people to realize that in the community system, in the crisis houses, staff are not allowed to put hands on. There's very hard for staff to control an elopement situation. We don't yet have community houses in the Agency of Human Services system with like fences or secure perimeters. All of these things could be explored and could be possible, and from our perspective would be far preferable to putting people with developmental disabilities who are not competent to stand trial in prison, potentially for life. And when I say potentially for life in this particular setting, I'm not being hyperbolic. I know you guys haven't gotten the walkthrough yet of S-193, but S-193 would allow for people who are not competent to stand trial. So that means they can't effectively assist their attorney in their defense. They might not understand the nature or of the charges against them. But think someone with dementia, think someone with an intellectual disability, think someone with certain brain injuries, and they might not be able to meaningfully participate in their defense. Such people will not be able to be restored to competency, able to stand trial by the intervention of medication or what they call milieu therapy. There isn't a drug yet on the planet that is going to change someone's IQ, that is going to reverse the effects of a brain injury such that someone would be able to be competent to stand trial. Restoration units and restoration programs are very effective for people with certain psychiatric disabilities, certain mental illnesses that are amenable to treatment with medication. And the law does allow people with psychiatric disabilities who have been charged with crimes, if the charge is serious enough, to be medicated against their will. And Vermont has some settings now where people are medicated against their will, and people are medicated against their will to regain competency or medicated against their will for safety. And medication and I'm not saying I'm a big fan of that, I'm just saying those are tools that currently exist in the system now that are available to be used to restore people to competency. One of my biggest concerns about the bill, the way that it's written, is that if you're not competent to stand trial for any reason, that's how basically it's written, any condition, organic or however obtained, if you're not competent for any condition because of any reason, you can be held in a prison. We're putting this into prison until such time as you no longer are suffering from the condition that led you to be not competent to stand trial. So again, an intellectual disability, a brain injury, dementia, any of those things are kind of forever. So if you're not competent to stand trial and you're in the prison, they're going to evaluate you periodically to see if you are still suffering from the condition that led you to be not competent. Well, you will always have your intellectual disability, your dementia, your Alzheimer's. So there's got to be some other, in my opinion, risk assessment done at that time. It's not just, do you still have the condition, and the way they word the risk, it's like really, it doesn't get to if you were discharged in the community, would the public be safe or not? And that's the risk assessment that needs to be done with someone who's not going to be competent. Competency is not going to be restored. At that point, are you going to hold them forever in a prison, or are you going to find an appropriate community placement little bit of background about me. It's not often my lived experience matters in this setting. But I did teach mental health law at a master's level for 5 years at the University of New Haven in the forensic program. And as an exercise for students, I also represented low-income adults with psychiatric disabilities. I did work at a forensic facility, at the Whiting Forensic Facility in Connecticut. I sometimes think I'm one of the few people in this building not employed by AHS or DOC who's been in a forensic facility. They're very different and if you haven't been in one, let me just say, they're very different. But the thing is that when I would have students for like a midterm or final come up with a commitment statute, come up with a statute for someone who needs a public guardian. You come up with the worst one, come up with the best one. Which state has the best commitment standards? And the thing that's just distressing to me right now is when I look at this particular bill 193, it is not a best effort of what a restoration process would look like, or where you would want to hold people for public safety who are either not guilty by reason of insanity or not restorable. The good people of Connecticut, I know they have a different tax base, but they're exploring gated housing for their long-term. So now under United States Supreme Court law, sex offenders who have served their time in jail, states can decide to never release them, and that is legal. If they're never going to be safe, states can keep them indefinitely in custody, even after they've served their prison sentence. So what Connecticut is exploring with this tool is a way to take some of their state property where the state hospital is, similar to the one in Waterbury, and create gated, secure housing. Because if people are going to live out their years into old age, do they really have to live in general population setting in a prison, especially on account of a disability or condition that's beyond their control? That whole purpose that we use correction institutions for, to change behavior and teach people lessons, it's kind of lost on people. People with certain disabilities, it doesn't work. It doesn't change their behaviors. The lessons aren't learned. But
Yeah, I have a question. One of the things that is a bit perplexing to me. So you've been around the building. We've had this discussion here more than once. So the last time, and I'll be asking the Dale witnesses this as well, but the last time that people sat in that chair and talked about why they felt they needed a forensic facility from the administration was because there were people who were sitting, there were one, maybe two people with developmental disabilities sitting in a correctional facility who they felt should not be in a correctional facility. And now we have a bill that's supported by the administration that says, let's do this in a correctional facility.
yes,
I find that I'm just, what is the DD Council's view of the appropriateness of the use of a correctional facility? Let's just say that there is I'll just say for argument's purposes, not that I personally believe this, but that we need a facility for individuals with developmental disabilities who are incompetent to stand trial. And thank you for clarifying what that means. It means that they cannot participate in their own defense. Would you be choosing a correctional facility as that location?
yeah, no. And, I think that one of the things that I included in my testimony or so, right, Madam Chair, this is not the first time the state has had this conversation. And in fact, the state had a similar conversation as far back as 2010 that I've been able to find. And at that time, the Dale commissioner was Joan Senecal. And what she said then, this is when there was a question about whether or not to create a facility for people with developmental disabilities at that time who were under Act 248. And what John Senecal wrote then, and it's as true then as it is now, is certain individuals who are particularly hard to serve in any setting. They may have complex psychiatric needs. They may be highly resistant to supervision. They may try to elope. They may be highly assaultive to staff and to peers, or they may be extremely emotionally volatile. These characteristics may make it difficult to supervise these individuals in a shared living home or a group home. It may be difficult to retain staff to work with them. When these characteristics are combined with risk to public, agencies may feel overwhelmed. In the past 2 decades, a few agencies have stepped forward to take on these exceptionally challenging individuals, but at present, no agencies feel able to accept hard-to-serve individuals from another region because of concerns about budget, liability, and community reaction. And I put this in italics in my testimony because it is this important. Some have suggested a small, secure facility to house a group of these uniquely hard-to-serve individuals, but it is unlikely that grouping the most hard-to-serve individuals together in a single location would be beneficial or cost-effective. The individuals who are hardest to serve are difficult and dangerous in unique ways. To assemble the combination of treatment and staffing resources to meet the differing needs of the individuals in a single location while keeping the individuals safe from one another, and I would throw in staff too, would almost certainly exceed the cost of our current individually tailored services. And so in her report, then Commissioner Senecal suggested that Vermont may wish to provide incentives for a current agency, and that would be like a designated or specialized services agency, to expand its capacity to serve these hard-to-serve individuals. One thing that's been very successful in general in the country, I had experience with it in Connecticut, and I suggested it to the Judiciary Committee, is that in the community, there can be forensic treatment specialists. They need to be paid more. Our agencies are not paid enough now, but for agencies to take on people who come with higher risk, or they might need higher levels of staffing, they need to be paid to do that work. But if they were paid and could hire and train community forensic specialists, what people have found, and I was privileged to work on a 5-year grant by the Melville Foundation, the people who are trying to end homelessness. This was a study on the homelessness of people with serious mental illness who were involved in the criminal justice system in Connecticut. And this won't surprise you. Guess what? When people had housing, they were less involved with the criminal justice system. When people had housing, they stayed on their medication more. When people had housing with support services, they got employed. It was just so much better. Connecticut does not have what we call outpatient commitment, the ability to put someone on an order of non-hospitalization and require them to take medication in the community. Connecticut doesn't have that. The study that we did was kind of like leading them down that path, but Vermont does have that. Vermont does have orders of non-hospitalization. And what keeps coming out in the Judiciary Committee and elsewhere is we need a forensic facility because that system is broken. We need a forensic facility because the people on orders of non-hospitalization, no one is checking up on them. No one is making sure they're following their orders. But you know what? I believe if we had, it doesn't have to be that every designated agency has specialists in this area. But if there was one designated agency or one in each region of the state that had forensic treatment specialists that were able to check in on the people on ONHs and engage them, and if we were able to link things like housing or other community supports to people staying and engaged on their ONH, I think we would have a more success in keeping the people who are on ONHs on ONHs. It's very hard. You guys know this probably better than anyone in the building. If you're unhoused, to stay consistent with any medication regime, and let alone one that requires, refrigerated medicine.
I have representation.
Trying to think through this. So if someone's on an order of non-hospitalization and there's a treatment plan, but that's not necessarily applicable, is it, to the instances you're talking about of someone who may have Alzheimer's or developmental disability?
Right. I was just going to actually encourage us to focus in on the people. So I am sure that the Committee on Healthcare will be taking testimony on this bill as well, and they'll be dealing with the ONH all the O&H stuff. And I happen to, we have heard in this room before about O&Hs and the lack of oversight and the use of those, but not for us here. So what I'd be interested in, if we can, one of the things that I know is that we have people in community-based services who have been ordered into the Dale Commissioner's custody under 38. People who have been adjudicated to not be able to participate in their own defense, have been found incompetent to stand trial. And do you know, I'll be asking Dale for this, so I guess, does the DD Council have any interaction with the success or lack of success of community providers in currently serving those individuals under Act 248?
So the thing that I'm most aware of with the community providers are the ones who were operating the 3 crisis homes. And the situation there during COVID just really broke down in that they weren't able to move people out of those crisis homes. And my hope is that if we just have more housing available in general, the pressure on those crisis beds would alleviate. But I also haven't understood why we only have 3. They seem to be so effective. Why don't we have 6? And I don't know who establishes those or operates those, but when I think about the costs in so many different ways of having something like this in an institutional setting, I just think we haven't explored community alternatives. The thing that I want to say that before you do the walkthrough, just something to keep in mind when you're doing the walkthrough. So this committee is probably more familiar with what happened in Woodside than any other committee. But what happened in Woodside was the Agency of Human Services was operating an institution and people were being harmed in that institution. And because the Agency of Human Services basically functions as an agency of one, that's their mantra, whether it's Department of Children and Families or Dale or Department of Mental Health. What Christopher Winters, who was DCF commissioner for a brief time after Woodside and before he's doing what he's doing now, was after the big article in 7 Days came out about what happened at Woodside, and really it kind of shocked the conscience of Vermont in ways that's kind of hard to remember now. But Chris Winters in a public hearing then said that there must be transparent oversight and accountability for the entire system, but even more so at the higher levels of care, particularly in any locked or secure areas. And then this is the biggest takeaway. And I have some ideas about this problem, but this problem has not been solved. His biggest takeaways was the state cannot be both the ultimate regulator and the provider. And the thing about Woodside, not for nothing, 7 judges had eyes on what was going wrong there. But what happened was they would have an individual child's case in front of them. And when it looked like Judge Mary Miles Teachout was actually going to write an order that might have placed down, that case got released. Case was moot. So Defender General Matt Valerio, he's very articulate about even when you had it before judges, even when you had lawyers, it just went on. And what would have been really helpful was some outside organization with eyes on and some authority. And so nationally, there's a protection and advocacy system that was created in response to the terrible conditions at Willowbrook and Wayback Machine when Geraldo Rivera was an investigative journalist. And we created a protection and advocacy system. And in Vermont, Disability Rights Vermont, used to be known as Vermont Protection Advocacy, is that entity. And with a psychiatric facility, they have 24/7 unannounced access under federal law. Someone needs to have that kind of access authority to this facility written into the statute so that they can go in, and they need to be resourced. Having worked at one of those agencies, there's nothing worse than being like, I was a supervising attorney with 4 staff attorneys and we'd get calls from people who needed our help. And there's nothing worse than having the responsibility to answer those calls and not having the resources. Because when you're calling from a facility or your family members calling from a facility, it can't be like no help's coming. There has to be an out there. And a lot of the people I'm concerned about, they're not going to be verbal themselves, but they might have family members. And one of the things about the protection advocacy system is they are allowed to visit facilities and walk around, eyes on. And that's to find the people, ordinarily lawyers can't go up to someone and say, hey, I can be your lawyer. It's called ambulance chasing. But there are really strong protections written into the protection and advocacy system that allows lawyers and advocates acting under those lawyers' licenses to go up to people in facilities like this and say, hey, when's the last time you had your court review? What's your treatment plan? Because people don't even know what their rights are in these places. So they're allowed to have people visit them out of the blue and talk to them about their rights. I can't even tell you how important it is to have something like that available, especially if this facility is in a prison, because where these rights might automatically attach into a place like Brattleboro Retreat or a state psychiatric hospital, they don't exist in prisons. But if this population of vulnerable people is in a prison, they should have a through line to the advocates who were created to protect people like them.
And I think we certainly have seen recent news reports around the problem with accessing individuals in terms of immigration and access for legal representation and information and translation services and people. So a correctional facility, no matter how much you try to dress it up and take it out, it's still a correctional facility. And so I think, and it still runs like a correctional facility. I think that's you're not going to be able to make a correctional facility run like a group home.
In the bill, which you're going to get a walkthrough, there is language where they try to do that. They want the correctional facility to have a community placement feel. And I was trying to picture how that would go. It wouldn't be unreasonable if they had separate houses or something like that. But the idea of having people mixed in general population,
I doubt that that's the idea about having them mixed in general population. Just to be fair, I don't think that is what the plan would be, but we will hear from the Department of Corrections as well. We'll kind of have the whole parade of folks. It looks like Representative McGuire.
No,
has something to
I'm gonna remain silent.
say. Okay,
And once we go through the walkthrough, then I will voice,
okay.
I do want to say,
So yeah, go ahead. I just
Okay.
want to make sure that, I'm not sure that I guess I would love for you to be able to summarize your testimony and tell us what the DD Council believes about this bill, if there's anything positive about this bill, or if you have, I have not read through your written testimony yet, or if you have specific suggestions about language.
yes. So I'll take that last one first. I understand from the chair of House Judiciary that they're going to have a new draft this
Tomorrow, I understand, yes.
I understand that some of the suggestions I made in that committee might show up in that draft. I will just say at the outset, the DD Council's been a little bit perplexed how to work on this bill this session. The confusion comes from, do we think this thing is going to go forward? Do we try to make it better? Do we try our hardest to get a study committee because we think it's that bad? So on the Senate side, the language that was first in the bill was the really archaic and offensive, my apologies, brain disease and defect language. So I testified about, I have to give it a trigger warning when I use that. That's how bad that is. So they took that out. And now it's this other language about whatever condition caused you to not be competent so I don't know, is that a win? So the DD Council and our policy committee, we have absolutely taken a position against the institutionalization, particularly in prison, of people with disabilities, people who are not going to be competent, ever restored to competency, should not be in a competency restoration program. One of the things that I did try suggesting in the Senate Judiciary, and I might try suggesting it on the House, is to really try to separate these missions from the restoration function, competency restoration. Just do that. And don't include the people who can never be restored, dementia, Alzheimer's. Just have a restoration program for people who can be restored. And then the state seems to think it has a long-term housing, protect the community safety issue from people who are not guilty by reason of insanity or people whose competency can't be restored. If you need long-term housing that's secure from the community, create that. But they're kind of creating both of these in the same bill, a way to keep people behind bars forever if they are NGRI or not competent to stand trial. Those are two really different groups of people. And I think because they say things like, we only have 6 people, the distinctions between what category those 6 people might be in might get lost. But the category of someone who's not competent, not restorable, is really different than someone who's not guilty by reason of insanity. And just in terms of the risk they might pose to the public, they could be really different. And so I just think we could be more, we could do better.
Right now, as you said, both of those are considered individuals eligible for placement in this forensic facility. I use the term loosely. And they are very different. And I on first read, I don't feel that what's currently in writing recognizes the substantial differences enough. There's or the differences in what might cause somebody to be competent to stand trial. So that's as you noted, a person with a developmental disability is a lifelong condition. It's not a condition that you medicate out of, or you teach out of your disability. If you have that disability, you have it for your lifetime. And I think that that it feels insufficiently recognized. And the concept of restoring competency, doesn't seem like a logical activity for somebody with a developmental disability. And I will say, I just want to make sure that people understand what I'm saying. I'm not saying that a person with a developmental disability is always incompetent to stand trial, because they in fact have been found competent to stand trial. And that is perfectly appropriate. And they participated in their own defense, and they've been found guilty or not guilty, or however the judicial process works. So I'm not saying that a person with a developmental disability is always incompetent to stand trial. But if they have been found to be incompetent to stand trial, they're not going to all of a sudden become competent to stand trial. And that means that they have the potential to, frankly, languish in a prison for the rest of their life. We know we can do better because we have been doing better in the community. So we'll see where this goes after we have a walkthrough, and we'll see new language tomorrow. So thank you very much for being here this afternoon and getting us started on this road. And we'll see where it goes.
Thank you. And I just want to say for the record, Anne Donahue's voice is so important to this conversation.
Yeah.
I don't think there's really anyone in this building who studied the laws around this topic as thoroughly as Representative Donahue.
And I can tell you that it was on her mind when I visited her earlier this week. And we will miss.
Surprising.
I know, we will miss her in this conversation for sure, and do our best to. We do not have the legal mind that Anne has, but we'll try to channel her as best we can.
Yes, well, I think I'm both sad and happy that it was on her mind.
I know, right?
That's right.
For sure.
Thank you.
Okay, thank you very
Thank you.
much.
Thank you.
Okay, committee members, I do want to let you know that we have received additional written testimony on S-157. Your review, it's, if it's not on our website, it's, about to be on our website, from the ACLU. So. For your review prior to us taking that up tomorrow. Okay, any comments, any thoughts? All of a sudden, what seemed, like, a routine and last month of the session, we have a bunch of Senate bills that we're gonna be looking at. Get ready, fasten your seatbelt. We're going to have to move them faster than the first half of the session, when we decide what to do with them, okay? And tomorrow I have not scheduled anything after floor in anticipation of floor being sometime. And
snacks.
and on Friday, we're supposed to have a field trip, but stay tuned depending upon any amendments that appear between second and third reading on the ed bill. We may have to reschedule that, so we'll see.